there a way out? And there are two ways out. One is you take a license, the other one is you filter. At least that's how the public debate has been shaped up in this area. So what we will do now in the next panel, look first at the way out through licensing, okay? So we have an excellent panel. Valentina Moscon is not here. She is ill, so excuse herself at late notice, but we have 4 excellent speakers. So the first one is Frau Pedro Quintes from IVIR, University of Amsterdam. Then we've got Charlie, how would you say?
I look after international legal for Twitch, which is a streaming site and part of the Amazon group.
Okay, that's very helpful. So, and then we move on to Sassem should be at the end, really, according to the order. But again, you're excused. So, would you introduce yourself as well, David?
I'm the General Secretary of SASEM.
Okay. And lastly, we move to visual artists. It's Carl. Would you say?
Yeah, Carola Streul, I'm Secretary General of IVA, and that's representing collecting societies for fine arts and photography.
Okay, thank you very much. So, before we start with 5 minutes each, I allow myself a few words. So, once we established liability, how do we make licensing happen? I see there are 2 key problems on 2 sides. So on the one side, how do you assemble the right license packages? So how do you get the package that you then license? And will it cover all kinds of UCG content? Will it cover music, text, games, Bollywood movies? How do you assemble the packages you then license? And then on the other side, how do you enable a pan-European license? So how can the idea of a digital single market happen? Okay, so I think these are 2 really kind of practical problems on the side of assembling the rights. On the other side, on the side of the platforms, the main problem is how do you force platforms to take licenses? Okay, so they mention questions of price, questions of sanctions available, and both of these sides have to be solved. Otherwise, there will be no licensing market, and there will be no implementation of Article 17 that reflects its ambition. So that's how I see the kind of the big picture. I will probe on some of these. And I'm sure everybody around the table will have their own take on it. But first, I think I give the floor for 7 minutes to Joao.
Thank you very much. First, I'd like to thank the Martins for the invitation. I really enjoyed the first panel, covered a lot of my doubts. I think I have to start to say something maybe Cedric mentioned, that it's never happened to me that when I start reading a provision, and I always start making notes before reading articles on it and scholarship, that I end up with 30 pages of comments. And so that tells you a little bit about the complexity of this. So for this panel in particular, I think we have to look at first at the concept of authorization. It has kind of 2 roles in Article 17. In paragraph 1 is as a consequence of this new legal qualification of acts of, I'll call them sharing platforms, to not use the acronym, and in paragraph 4a for best efforts. So I think I'll leave best efforts for now and come back to it during the discussion. So I think the starting point is what we mentioned already, is that Article 17.1, in my view, creates a special regime. Whether you call it a sui generis right of communication or not, it's definitely lex specialis to Article 14.1 of the e-commerce directive and to Article 3 of the InfoSoc directive. And the latter point, I think you find proof or support for that in recital 64, but also in the 17.2. The second paragraph talks about a shared act of communication to the public, which I think has 2 constitutive components: upload of the user for non-commercial purposes, or objective non-commercial, and carried out by the platform. Now, this has relevance, as we'll see forward, I think, for the licensing, including for collective licensing. Because if this is a new right, we're talking about, for collective management organizations, is there a need for a new mandate or a need to change the current system that they have covering the Article 3 right? Now, forms of authorization. What do we have available? I think here It's illustrative also to read not just the recitals, but the German statement. In the joint statement by 3 countries, the German statement of the German government is quite powerful. And in paragraph 10, it lists several possibilities, and I'll list a few more. So you have direct individual licensing from copyright holder to platform. There's also an element of indirect licensing from copyright holder to user that automatically includes the platform. This is in 17.2 and in a recital that says if the user has the right to upload the work, then the platform is not liable under this regime. We shouldn't forget that. That might be important also to calculate fees. And then we enter into the mechanisms of collective licensing, either voluntary mechanisms like voluntary licensing and extended collective licensing, which has a new regime in Article 12, mandatory collective management, and we go further down the road, and the German government mentions this, statutory licenses, and some sort of hybrid remuneration right. Now, my idea is to go through this very quickly, and then we can pick up on the discussion. So direct licenses are as a possibility to a pan-European license or to all the content uploaded on the platform, or the main content, if we take to heart the definition. The platform should actually only focus on licensing the main content, at least on the core of their best efforts obligation. Direct licensing will be unfeasible for most. So I think the actual possibility that we have here, or where we're going towards now, is either a combination of direct licensing with collective licensing or voluntary forms of collective licensing, including extended collective licensing. Now, problems with that, none of these regimes is designed per se for pan-European licenses. We could argue that on the online music sector, things are a bit different, and this would be possible, and we even have a specific regime in Title 3 of the CRM directive that allows multi-territorial licensing of online rights in musical works, and there's sufficient aggregation on the performers and recording industry side to allow pan-European licenses, perhaps. But for most of the other types of content that we're talking about here, this would be challenging. There's no actual legal mechanism. So I think we also have to see how extended collective licensing will be implemented in national law, but it's this only currently we have it in about 8 member states, 7, 8 member states, and we'd have to see how it actually is implemented throughout if it's a solution. Now, in my view, reading the text, there's very little basis to argue for the possibility of a compensated exception or statutory limitation. The right is designed even as a special right, as an exclusive right, so it will be very difficult to pass the very restrictive interpretation of the 3 test by the court. I've been very critical of that interpretation, but I don't think the actual legislative text allows much for it. What's more intriguing, and maybe I'll leave it up there for the discussion, is this possibility that I think we have some Spanish scholars in the audience also could clarify this, of if we consider this to be a special type of right, can we actually turn it into a remuneration right, and to ensure the possibility of a facsimile or proxy of exclusivity include an opt-out? And you say, oh, this sounds super weird, but actually the directive already includes that in the fallback, one of the fallback limitations, which is an exception and limitation with opt-out. So I think in this particular sense, considering a remuneration right with an opt-out, if the market failure transaction costs arguments apply to licensing all of the content on the platform, it's something we could explore. Is this a solution? We'd have to go country by country, territory by territory. We don't have a European competence or European legal mandate to do this in one of the legal instruments. So without legal reform at the European level, this would have to be done country by country. Some countries might do it, others not. But this might provide an option, a combination of these mechanisms to actually license what we want to license, which is, and I remind you, most of the content uploaded by users we don't know in advance, that's uploaded by users to a platform. So to end up, if that's what we want to license, to obtain such an umbrella license, we need a mechanism that goes beyond individual direct licensing. So I would leave it at that. I have some ideas on the best efforts, how we can modulate it to facilitate this, but I think this provides perhaps enough food for thought for what comes after.
Yeah, we certainly will come back to best efforts. Okay, so Charles Singsby, now your 5 minutes.
Thank you very much, the Martins, for inviting me and for getting us all together. It's great to have so many smart minds all together in the room. I think since we're speaking among friends, we all know that if you want a problem solved, get lawyers on it. Maybe if we have 5 minutes at the end, we can solve Brexit too. That would be great. So I want to talk about this essentially from a practical solution, and Cedric kind of raised the very good point at the start, how do you practically implement this, and looking at it through this licensing lens? And also, we have to think that we have got, I think now 22 months for the national implementation of Article 17. So how do you go up even kind of trying to organize a licensing regime? And the first issue is that we don't know what we don't know. So with kind of copyrighted works, of course, there are certain acts that we all know will attract copyright. A Beyonce video, for example, we do know that attracts copyright. When we go out for music labels, we have the 3 big music labels. If we go out to them, they control, say, 80% of the market. Does that constitute best efforts, endeavors to go out and try to organize licensing with them? Is that sufficient? If we take apart all of the different content that is shown on these platforms, say 40% is music videos, 30% is football rights, 10% is photography. Is it enough to go out to the Bundesliga or the Premier League and license those rights? Is that the problem solved? What the real problem is actually with that kind of ultimate 20% where we don't know who owns those rights. And so we need some kind of form of cooperation from rights holders on this. And some very bright minds have been thinking how best to do this. You almost need to have a source of truth where rights holders can upload their licensed rights, and there you have the opportunity to license against those rights, and you also have the opportunity to use that technically to detect against what is a copyright right. Because otherwise, someone has a piece of music on one of these platforms, say on YouTube, we don't know, is it out of copyright? If it is within copyright, who owns that copyright? Who do you organize a license to? Is there going to be a dispute as to who owns that copyright? How are we going to resolve this dispute? So all of these issues need to be kind of resolved by some database, some universal source of truth that everyone can feed into. And there needs to be a reciprocal obligation on rights holders to be able to make this happen. That way you match rights holders with the platforms, and then you can organize the licensing off the back of it. So then you come, which rights will attract copyright? Are we, music rights attract copyright? Video, even t-shirt manufacturers were saying, and each person wants their cut. And at what point do you get to the point where this becomes too expensive? It breaks the business model of the platforms. Because, of course, you're paying out all of these rights holders. Each person wants their 5 or 10%. And we know kind of Spotify, for example, pays, I mean, close to about 75% of its revenues to rights holders. There, you've got to factor in hardware costs. You've got to factor in operational costs. And God forbid, some of these platforms need to make a profit as well. So we want to strike that right balance in any implementation, because otherwise the model will collapse. And this will be to the detriment of European users, European creators, and tech companies as a whole, some of whom are even European themselves. Thank you.
Thank you very much. So we move now, we stay with the order of the program. So it's Carol Sproil now. 5 minutes to you.
So good morning, ladies and gentlemen. Thank you very much, Martin. Thank you for the invitation. It's really very interesting to be here and to hear all your concerns about this directive. On the other hand, as far as my sector is concerned, we are in the first place extremely grateful for the directive. It is a very good step ahead. It had been the result also of a very transparent and democratic legislative process where everybody was heard honestly over many, many years in many details, and where even the opponents of 15 and 17 had a lot of saying, and they were heard, and there were many issues entered into legislation. To say later on maybe that makes it confusing is somehow also a bit counterproductive. We have a good directive now, and we work together to make it happen and make it work. And there are, for the visual repertoire, besides of Article 17, there are many very useful things in the new directive, concerning also the relation to cultural heritage institutions, for instance. But 17 is for us very good to have an opportunity to find ways to license. License is for us the issue here. That's what we are going to do. To do licenses and to end what is happening until today is a very unfair exploitation of these works on sharing and social media platforms. So I think that's my starting point I wanted to make here. And I want to tell you a little bit what our members are doing, and because it's often not mentioned that there's also the still image, but it is there, and these are works with rights connected. So EVA is representing 28 European CMOs, and they together give the entirety of societies in Europe which are managing a visual repertoire. So the work categories comprise fine arts, photography, illustration, design, street art, comic strips, architecture, and many others. So everything which is a still image enters into this kind of societies. And we, for instance, our members represent very renowned artists like the estate of Picasso and Gerhard Richter, but also of many, many authors that are little known or completely unknown. And if we look at, they also have a very broad application of rights they are managing, and they are in discussion with all players in their countries and cross-border. And left 2 minutes. Okay, so that's to that. As concerns Article 17, our proposal for looking onto this is, first of all, something we built up about 15 years ago, is a multi-territory, multi-repertoire one-stop shop, where we have societies and the repertoires joined not only from the European Union, but also from the United States, Canada, and Australia, and so forth. And they have designed that for online global licenses. And this is so far mostly used for the traditional usage. For instance, a museum in one country wants to add the content on their websites or then on Facebook, and these kinds of licenses are given by this one-stop shop. And what we created it for as well are platform users, to have also multinational acting players and give them licenses where they have in one go the entire international repertoire. This is one thing, but that would be a kind of direct licensing, and the non-members of collecting societies would not be comprised, so there will still remain a kind of uncertainty as concerns the licenses. So what we favor at the moment is, and checking how that could work, is the Article 12 extended collective licensing for Article 17 users. And that is something we are checking through. It matches with many things, of course. The limitation to territorial are set back, but that's also a question of the implementation, of course. And so it could be that in more than 8 countries we have somehow referring things. And the other thing is that we could look into this hybrid remuneration right, and also base it on Article 18 with the right to an appropriate and proportionate remuneration for those authors who have to, who are licensed exclusive rights. That could also cover them, for instance. So that is what I wanted to say here. All the other things, I mean, what was raised already, that we will start to discuss with all parties, and we will also apply everything in common sense. So if you have, for instance, a question here from the colleague from Twitch, you can't say it's 10% or the level is 5% or something. It depends case on case, and we have to look. And I'm answering already on something which was said here, so that wasn't necessarily in my 5 minutes. But I would say it depends on whether a platform uses enormous amounts of contents, and then also 1% can be a lot, and they have to exactly go and collect all the rights of the content on their sites.
Thank you very much. And now it's the turn of David El Sayek from SASEM. 5 minutes.
Okay, 5 minutes. Thank you for inviting me. Different issue was raised. And I think also my intervention is linked a little bit to the first panel, because if you want clearly to understand the licensing issue, you have also to understand what were obstacles to get a proper license with what we call UGC platform. I'm not saying that all UGC platform didn't want any license, but we have some refusal. And the main reason, legal reason, advanced was the first one: we do not carry out a communication to the public act. And the question was a question. In certain countries, for instance in France, the court considered that a platform carry out a communication to the public act because they give access to protected content. But we knew that in Germany there was a controversy and different decision rendered by different courts. So the question whether the users or the platform carry out a communication to the public act was a crucial question and was not an easy one. And Article 17 provides a very clear answer. And I don't think that it is a sui generis right. It gives just a presumption. Why? Because as long as you give access to protected content, the text provides that the platform is carrying out a communication to the public act. And when you see all the different criteria used by the court in 18 different rulings, it is sometimes a very difficult task to demonstrate that such entity carry out a communication of a public act. And this question is raised every time in the online worlds. We have seen the case, the Svensson ruling, the GS Media ruling, the Melwater ruling, but also in the offline world. When a hotel gives access to protected content, does it or not carry out a communication to the public act? So it is very important for us to have this point clarified by the directive and Article 17. The second point, which is crucial, is: are you responsible for such acts? Because in the online world, there is Article 14 of e-commerce directive. And nobody contends the fact, for instance, that a mere host provider carry out a reproduction right because it stores the content. But is not responsible for that, due to the fact that it could benefit from Article 14 of e-commerce directive. So the question to claim the safe harbor provided by Article 14 is also crucial. And when we had discussion with new UGC platform, they say, okay, I might carry out reproduction and or communication to the public act, but I'm not responsible for that. And the only thing that you can do is to send me notices and I will take down the content. And if the content reappeared, you have to send notices again and again, because they refer to 3 rulings of the Cour de Cassation in France in 2012 that say that there is no state aid obligation due to the fact that Article 15 of the e-commerce directive is applicable. So it was another issue. This is why the text also clarified the fact, as long as there's a kind of active role by promoting and organizing the content, the platform could not invoke whatsoever Article 14 of the e-commerce directive. That was the main 2 obstacles. And I think the directive overcome these 2 main obstacles. Then you have the license. And we want license. I heard that Article 17 was about enforcement measure. I tend to disagree with that. What we didn't like in the proposal from the Commission in 2016, that was only two recitals about licensing, recital 36 and 37. But no mirror provision within the directive regarding licensing issue, only a very vague obligation of cooperation. This is why we insisted to obtain very specific provision regarding licensing deal, because it was the main, our main goal. We didn't want to destroy new service. We are not acting on an exclusive basis. We want our content provided by those platforms. We like YouTube, we like Twitch. It's important for our members to have also an exposure from newcomers in the internet world, but we want a proper remuneration. And what we want also is transparency regarding remuneration. And I think that Article 17 is very good regarding this point, since Recital 68 and Article 17, paragraph 8, provide a sort of reinforcement of transparency obligation. We want to understand how the business model is working, why some content are monetized and why other contents are never monetized. There is a huge value gap when you compare the remuneration generated by a streaming service platform. I would say use three figures. When you make 1 million of stream of view on YouTube, SACEM pays you around 150 euros. When it is a freemium service, such as Spotify or Deezer, is 1,000 euro. When it is a subscription service, because no, but you understand why we ask licensing and more transparency. It is 2,000 euros. This is the gap that we want to reduce. I'm not saying that Article 17 will solve everything, but it will give us, it will enable us to have the legal grounds in order to have better licensing agreements.
Thank you very much. And apologies for interrupting. So our ambition today was really not to reenact the policy debates which led to the directive, but to address some very precise and difficult questions. And so I will take now the liberty to ask a few of those, okay? And I hope that you're brave enough to answer them. The bravery in the first step goes to the industry, and if somebody in the audience is willing to do it, it would be helpful. So the first question is, we heard in the last panel, and I think there's agreement, we have a new right, okay? We have a new right. So CMOs, do they have a mandate? Okay? So it's a very precise question. Do you need to go back to your members and acquire new rights or not? Yes or no? We start in the back.
No, no new right. This is a communication to the Public Act. Otherwise, it would have been written that there is a new right. It refers directly to Article 3. The question was not to establish a new right, was to determine who was liable for such right. And the question might be raised since there are two parties, two entities involved in the communication to the Public Act. The users, who provide the content, and the platform, which give access to the content. So what has been solved by Article 17 is that we now are sure that the platform play a role and is carrying out a communication to the Public Act. So there is no new right.
Okay. So same question to Carol, really, for visual rights. Do you have them?
Yes, of course. I mean, communication to the public is a right that we have in our repertoire since very long. And as I said before, we used this in order to create also a one-stop shop on that back in 2002, which is still not used for, but in future will be used. But so I think that's pretty clear. But what we will engage in is to have to attract more authors to join us to complete in the entire repertoires, to have more authors from those who have commissioned rights, like illustrators and photographers, which we are now having in remuneration rights, but we would extend more to them to have a more complete repertoire here. Yeah.
Thank you very much. An opportunity to respond, Charlie or Joao?
You go first, please.
Thank you. So I'm going to be the objection voice here. I'm not sure, but I really don't follow the same argument. I read this provision and with a neutral perspective, and I do think we have a special type of right. Whether this means or not that your current mandate covers these rights is a different question that will probably go to the court. But I'm afraid that the text of the directive refers back to Article 3 in a way that does not clarify that situation. And if that is the case, looking at it, it has different features. It has a specific liability regime, and I would say that my preliminary question is that in fact you would require a change of the license or an extension of the license to these rights. Now, by no means this is clear, but I think this has to be flagged. One aspect of this is thinking about turning into a remuneration right. I'm not sure you have the same leeway to turn Article 3.1 of the InfoSoc directive into a remuneration right as you have this specific right, and that indicates a different legal nature. So I would just leave it at that.
Okay. Charlie Thingsby?
No, I think you've covered a lot of the points there that one needs to make. It is then extrapolating out of that the practical application. How do you organize these rights? How do you organize the remuneration? How do you allow authors or photographers or musicians to notify platforms of these rights and then claim against that? How do you resolve disputes? And I think that is really where we can help the Commission kind of fill in on their guidelines for this to kind of make a practical compromise with this and move beyond policy debates into a practical implementation.
Okay, so my next question focuses on the best efforts. So under 17.4, there's a potential way out. If no authorization is granted, online content sharing providers shall not be liable if they can demonstrate that they made best efforts to obtain an authorization. So what we want to now know is what constitutes best efforts. So typically a platform may not know that's the nature of user-generated content, what content is on their platform. That's the nature. If it was different, then we would have a traditional broadcast channel. So the big difference between a television station and the UCG platform is that the user is active. So by the nature of the user, content will end up on the platform does not know about in the first place. So in this kind of context, what constitutes a best efforts obligation? Does it mean you have to cover all potential content? Do you have to cover all available content? How do you know what is available? And what is the kind of threshold at which you have to obtain a license? So these are a number of really difficult questions, and some of them have kind of hypothecations in there which are hard for you to answer. But let's assume we have a platform that has Bollywood extracts on it. Okay, Bollywood film have diversity we should support. What do we do? What do we do? Okay, so again, I think I just would encourage you to be brave. Take a position. What do I do to address that issue, and at what stage do I have as a platform a defense? Okay, anybody's brave enough to do that?
I can start off. Let's take your example, Martin, of a Hollywood film appearing.
I said Bollywood, which is even harder.
A Bollywood film appearing on the platform, and then you have the debate: is it the entire film, or is it a snippet, a meme? And if it's the entire film, you come into one of these online TV streaming services such as Netflix or Prime Video, which already license this. So you have the opportunity to license it in your own right there. The more complicated example is actually when it is going to be one of these memes here. which is for commentary, criticism, parody, is that how do you determine, and this touches on something that we're going to talk about later on in the day, is that how do you determine that this falls within kind of fair use? And therefore that the creators should be allowed to upload it, and also that the rights holders are suitably remunerated unless it falls under this fair use exemption. And where do you draw the line? This is the difficulty. There are no answers here. I can throw out something that, say a 2-minute clip of a copyrighted material is probably going to be used for parody or criticism. There's a reasonably good likelihood that that is going to happen. You're not deriving any kind of visual benefit from watching the whole film if it's only 2 minutes, but that is a sufficient balance to make. So one of the things that I'd be asking for to try to help the Commission here is say, look, can we make a cut-off here which is scalable, because you can't get human kind of review of all of these clips to say, is that commentary, is that criticism, is that parody? That's not scalable. And you can't use artificial intelligence for that. So when we look at it with that,
the question really, if I may come back to the question really, what I try to get to is there are different types of content on platforms, and what does best effort mean in the context of accessing right holders? So that is really the question I'm after, and I think it's very helpful what you said. Is it okay for just...
Yeah, if I can answer that. Is that when we go back, in my opening statement, we said there are 3 major music labels. They will have probably 80% of the music that is online on one of these platforms. Is that sufficient to go out there? I mean, we'd argue, look, that's best efforts. You've covered the majority there. And then what you need to do is also offer the opportunity for other rights holders where it's a bit more difficult to attribute who owns the rights holders to come to you and then organise a license. And that offering that, I think, probably constitutes best efforts there. You've covered the majority of your bases. That's the only way that I can see this being scalable.
Joel, you wanted to respond?
Yeah, no, thank you very much. So my idea on this, I think first we have to have the framework of what we have to consider. So you have to, in your question, you have to consider what type of authorization is required. So if it's collective licensing, then you have to know who's the target of my best efforts. The subject matter scope, what do I cover? I think we have to read the definition clearly to understand that you cover the main type of content. So yes, active seeking of license from the CMO that, for example, in collective licensing, that actually licenses that type of content for which territory. Here I have to say country by country licenses versus pan-European license. I follow the school of thought of accessibility, not targeting. So even if the platform mostly targets 10 member states, if it's available on the 28 member states, it might change what type of best efforts you do on the states that are not targeted, but you still have to license it, which means consequence geo-blocking. That's the incentive, not positive. It's more a Netflix model than a YouTube model. And then it's where it gets really complicated, is the specific type of platform. What will determine the type and frequency of best efforts? And that you have to, the article has some things. So the definition in Article 2.6 in the recital 62, the non-exhaustive elements in paragraph 5, including proportionality, and the tiered approach. And to be very concrete, I think we can use those, especially 5 and 6, to at least replicate the tiers in paragraph 6 for startups and up to 5 million unique visitors, and perhaps use that logic to define tiered best efforts obligations. Meaning that if you're a startup, you're probably not having to proactively seek much licenses. If you're a mega platform, then you have to full scale of best efforts for the territories covered by your license.
Do you see that as a question of implementation or for the Court of Justice?
I think this will go to the Court of Justice eventually, as most of this article will, because there will be different approaches for in national territories about what do I have to do as a platform of certain scale. And the court will have to draw, as it usually does, fuzzy lines. So.
Okay, David?
I tend to agree with you. I think it's not so complicated. And I think best efforts, of course, it's the question of identify the relevant right holders. And you have major stakeholders, which is very easy to identify. Your company last week at the midday came to my company in order to start a negotiation. So you take the lead, and we are happy with that, and we start speaking about a negotiation and a deal, and I hope at the end of the year we'll have a deal. And also you can provide tools. You can have a very easy access. Okay, your content might be available on my platform. Please contact us, and we will start a negotiation. All the platform can do that. It's not so complicated. And in the music business, you have majors, you have indies which are gathered into Merlin, you have online aggregator, you have CMOs. It's pretty easy. The problem occurs when no license has been issued and the liability incurred by the platform, because you have different kinds of right holders. You have right holders who want to have a license, you have right holders who want to block the content, and you also have right holders who don't care. The content is available, they don't want any money, they are just happy about the fact that their content are available on that platform. And you know that in the Article 17, the liability is only triggered if the relevant right holders gives the relevant information. Otherwise, no liability for the platform. And it is how it works. And I think it is a balanced way to promote licensing deal for entity who wants a licensing deal. Not everyone wants licensing deal. You have differences between licenses. You asked me a question about pan-European or non-pan-European. We do pan-European, only pan-European. We couldn't do further. For instance, with YouTube, our agreement covers 168 countries. If you ask for 168, we can provide as long as we have the rights, and we have the rights for our repertoire. So it is not a major issue. You might have different right holders. They have exclusivity deal. So you could have a pan-European deal, but on an exclusive basis. And you have right holders, they have only small territory, so it is specified in the deal. It's not such a big issue, and I don't think it is the directive to regulate this. You have also a room for negotiation between the stakeholders, but you have to clarify the principle. And I think what it is important and what it is very specific regarding licensing is when the platform license on its behalf, but also on the behalf of the user, as long as the user acting in a non-commercial purposes. And that was a crucial point, even for us. We wanted this point because we don't want to have how many uploaders on YouTube? 100 million different uploaders. We are not going to license 100 million license with individual user who uploads content. And we know that the money is generated and controlled by YouTube because it's a public cloud, but it's also a network advertising company which generates money or subscription. So it's not a problem for us. And I think it was a crucial point, and it has been solved in Article 17, paragraph 2.
Okay. Carol?
I also believe that most of these questions will be solved when we start negotiating with the platforms coming up with a question about their works that they have online, put up by the users, and that is something we do all of the time. I mean, our members, it's a core business. They receive requests. And there is also the first question is: Do we have the repertoire they need? Is it what they want? What is their work? Do they need a license? Is under acceptance or so? When you were talking about bloggers, for instance, and the question, okay, for us in many blogs, when they are about art, I mean, then it's on current events, for instance, you know, and we of course take this into consideration, and that has always an impact on the license that is then given for the rest. But that's absolutely how it functions, and we are also relying, of course, on the information given by platforms under 17.8. We need information that they have, also that could facilitate the distribution of money, of course. That's also something typically we do with all licenses in the analog world as well. Those users who receive a license also have to provide information, and those who sit on the source of the information are the ones who can give it, and not other people. So I think that's also extremely important. And again, I mean, if there's a Bollywood film, if there's not an artwork in it, I wouldn't say they have to come to us, of course. But I think you didn't mean the question as that. But if I mean, Instagram is a very clear case where we have lots of images. Photography, also galleries use it in order to publicize their collections and their offers. So that's absolutely clear that they should come to us and they will find us. I'm pretty sure it's not so difficult. And if they would by accident go to SACEM, the SACEM would say, well, go to ADAGP in France. So it's not a big. The copyright world is a small world, and we all see each other over 20 years in different places as well. So I think that's not exactly the big problem, and but we could, of course, increase the way to publicize the existence and the way of working. It's not a problem.
Okay, so I think it's opportunity now for the audience to pose a number of questions before we come back to the panel. Would you like to come to the front and take the microphone?
Thank you, Rich. Hi, thank you for this excellent panel. My name is Roy Kaufman, and I work for one of the few organizations in Europe that actually has IME status under the CRM directive. And what that enables us, what we do, whether it's because we have IME status or not, is we offer a collective license, not just pan-European, but fully global, for reuse of text works, primarily in the corporate environment. And when I think about the difficulties of national legislation, of having different rules, different regimes in each of these countries, I think one of the ways that seems to me might be useful, and I'd be really welcome the comments here. I think in the visual arts, you've got this solved because you've got this great pan-European license. But in other disciplines, I think a copyright owner mandated global, global, because we really need more than global. We don't just need pan-European, frankly, if we want to solve problems for global platforms and for global rights holders. I think that's kind of system might work. Now, it's never been used in this sort of context because, frankly, this is a whole new right, I believe. I think that seems to be, I wasn't sure of that before I came in, but now I'm convinced it's a new right. But what do we think of sort of a voluntary collective licensing where, because it's voluntary, you've got, you can meet the rights, the needs of the users, while also getting mandates from the creators so that you don't have to worry about implementing in each country, if that makes sense.
I can start. I think obviously it's one of the possibilities. The problem is getting the rights, and also the issue for platforms will be, as mentioned before, what do you do with non-members? What happens to the liability of the platform in regards to non-members? Because quite frankly, a lot of these platforms, no matter how comprehensive the license it is that you have, some of the uploaded works will be, or many of them will be from non-members. So the issue has to really be, how does that affect the liability exemption scheme in relation to best efforts in 4A and the rest of the provisions?
If I may, and I apologize because I'm obviously American, and in America the way it sort of works is if there's a license, you sort of have to take it, and if there isn't a license, you sort of don't have to take it. I'm oversimplifying the way fair use works, but that's sort of how it tends to pan out. Again, totally oversimplifying.
Yeah, Roy, it's a very good suggestion. I mean, what I'd like to know from a kind of practical perspective here as a platform is if I go and chat to you, do you have all of the licenses that I need? Is this a one-stop shop? What happens if I do a deal with you and then it turns out that actually you only kind of cover 40% of the licenses available. Look, what are the consequences, right? There's only one of me that goes out and chats to everybody. It needs to be scalable. Am I now liable because I thought that I was going out to chat to you? You know, I thought that I'd had that problem solved. Turns out, doesn't. I'm prima facie liable.
So I just want to follow up on what was said. So I mean, the way you can look at it is that with respect to non-members that are not included in these existing solutions, that you could say, well, if non-members, if best efforts do not include licensing with non-members, there's an incentive for non-members to organize themselves in the organizations that exist. So that's one way how you can look at it. So you can be and say, I'm a government, I think that's essentially incentive for them to organize. Or you could say, well, I don't think that will work, so I try to find a mechanism which tries to nudge them towards not necessarily organization, but in a way how I make them visible to the platforms, me as a government, by taking some proactive steps. I don't know, setting up a registry or something that I do as an extra step. So I think there's several ways that you can address that. But I think the primary thing to look at it is from the perspective of how do I imagine that right holders who are not being covered actually will react to this? Because of course I want them to be remunerated too. I mean, this is not meant only for the majors. So what do you think of that?
I don't think that the non-members issue is a big one. Why? Because you're not obliged to be a SACEM member, for instance, so you can get in touch with the platform and try to negotiate. It's cumbersome when you're a small group, of course, because it doesn't make life very easy for the platform. So most generally, there are members. In the musical fields, we represent almost 100% of a music composer. But you might have, from time to time, non-members. But the question is about the liability within this context. And you know, if you are non-members, you're not covered by the license, and you don't react, and you don't provide the platform with the relevant information, no liability could be triggered. So what will happen? It's pretty simple. The ones who want a license, they will go and get in touch with the platform, and they will negotiate a license, and I hope that it will be solved quickly. The one who doesn't want their content available, they will provide the relevant information in order to block such a content, and we will see that it could have some discussion around the fact that some lawful use should be preserved. And among the lawful use, there's not only the exception, there's also the fact that I give a license. If I give a license to your platform, the content should be available. I could not block such content. It's how it works. It's how it works with YouTube for many years. We don't block any content till when it is covered by the license. And there are people who don't care, and the people who don't care, the content will be available. And no liability will be occurred within this context, because they didn't provide the platform with the relevant information. This is why I think it is a balanced scheme adopted by Article 17. Of course, there will be sometimes people will think that there is a problem about exception, but it has nothing to do with licensing deal.
Can I just, so very quickly, I think we also have people that actually also work in other collecting societies want to intervene. I think one maybe legal precision, I think you keep coming back to B and C, but in fact these are cumulative conditions. So if I don't meet the best efforts authorization, I don't have a liability exemption irrespective of whether someone approaches me with the information. So I'm liable, period. So that doesn't solve the problem.
I disagree with that.
Well, I think, well, we can disagree, but I think that's...
You have to provide relevant information. It is specified in the text.
But if it's
no liability could be triggered if
yes.
you didn't provide relevant information.
Not so much. So if you are an online content sharing service provider, you are communicating to the public. Now you have a liability exemption scheme in 4 that has cumulative requirements. So if I don't establish that I met the criterion A, it does not matter whether I got the information for B or C. I am liable, period. This is quite clear in the provision. Now, there's maybe I think Burak and also Tobias wanted to intervene on what CMOs could do because there are legal mechanisms for exempting liability in relation to non-member claims already in national laws. They exist. Some collecting societies might assume the liability in relation to non-member claims because they say their blanket licensing covers enough. But yeah, maybe you can add on that.
Can I just have a short follow-up on that? I can do it here.
Yeah, sorry.
So in the sectors which are based on individual licensing, so where there's no tradition of collective licensing, would your answer change?
But just, I don't understand. Best effort, it's not an obligation of result. Of course, if you don't do anything as a platform and you make available some content, you might be held liable. I tend to agree with you. But if you provide best effort, if you contact the identified right holders, if you provide tools in order to get in touch with different non-identified right holders, you fulfill the obligation of best efforts. It's not you need to cover every content by license. It's that you have to be a little bit more proactive in order to reach a license. But it doesn't imply that every content should be licensed with the relevant right holders. And when there is no license, the liability system is with mitigation measure. And the trigger of a liability depends on the fact that you provide or not the relevant information. Because I totally agree with you. How could you identify the right holders? You might know that you provide protected content because you see music, audiovisual product, and you see that they do not belong to the public domain. But you're not in a position as a platform to say who belongs to, what content belongs to who. It's impossible. You don't know if it is Warner, Universal, SACEM, GEMA. This is why the text clearly specified that we need to demonstrate the constituency of our repertoire. This is a crucial point for me.
So we've got, there are two more music collective societies, which in itself is a indication of the way the debate is shaping up. And I think I'm aware that we need to be sure that we hear the voices from other sectors of content. I don't know whether they're in the room, but it seems to be not the right approach if we just focus on music rights, where we've got a very established licensing regime. So we've got visual rights. Should not be forgotten. But what I would ask, if I give the floor briefly to Gesak and GEMA, be aware that we need to give space to other industries. So I finish the music sector and then I give the word to you. Okay.
You will be surprised I was prepared to say something on the non-music licensing. I think my point was that if you look at the history of how collective management has evolved in other fields, like there was always the exclusive rights and then there were the collective solutions coming later on. So it would be surprising if this would be the other way around this time. So of course now a lot of collecting societies in other fields are currently adjusting their mandate agreements, photography, text, things that were now not so much subject to collective licensing in the online world, and that are now of course setting up the structures. First point. Second point I wanted to make is on the liability for the best efforts licensing. My concern is not so much the liability of the platform, because I'm confident that there we will find a solution like you've outlined. The bigger the platform is, the more active it has to be. Smaller platforms can be more passive, basically just put a note on their platform saying, well, if you're interested in licensing, please call us. So I think there will be solutions for that. My problem is more the uploader, because the ideal behind the directive is the platform immunizes the uploader. That's the ideal, right? So the platform gets the license and then the uploader is out of the picture. But the problem is no platform can license 100%. They would maybe 80%, maybe 90%, depending how active they are. So what happens with the uploader for the remaining 10%? I think this is where we need solutions. This is where we need solutions to be sure that the people know when they use this platform. If the platform has acted diligently, I'm still out of the liability if I upload content on this platform. This is, I think, the more pressing issue why we need, I don't know, extended collective management rules or some type of legal presumptions of what repertoire was covered.
Well,
not surprisingly, it was on a similar line what I was going to say. It's actually provision is in a way an incentive of having more licenses. Sorry, my name is Burak Özgen. I'm from CESAC. CESAC is the organization representing author societies at European level. So, and then we have many music rights, many music collective societies, but we have also visual arts, audiovisual author societies as well. So directive is in a way actually a little bit an encouragement and promotion and actually incentive for more people to become members and get involved with the collective management organizations to make sure that the licenses given to services are covering them as well. So because now it's clear that actually the platforms need to remunerate the creators, and the creators have an incentive in being part of it. And I think it's good for everyone because it makes the content available for everyone and then remunerates the creators. And on the part of the mandate, I just wanted to make the point that actually the Article 17.1 clearly says that the platforms need to get the licenses from the right holders that are specified in the Article 3 of the InfoSoc directive, so it does not raise any mandate problem. The right holders that are holding the communication to the public.
Sorry, the right holders might be the same. I think the argument here, and it's not a clear issue. I'm not trying to say this is the right solution. It refers back to the categories of rights holders, that other provisions does, but it doesn't refer back to the actual right there. So if you interpret this as being a new right with the same rights holders for convenience sake that you mentioned there.
Yeah.
But
I mean,
every CMO has online categories. We are obliged, due to the CRM directive, to make specific categories about online right. And if you want to know exactly, we even make a distinction between interactive online rights and non-interactive online rights in order to enable our members to withdraw such categories if they want to give it to GEMA or want to give it to other entities, because we compete against each other when it's about online rights. So it's already in our bylaws. We cover streaming on-demand services. But for me, as long as we refer to Article 3.1, it's still communication to the public. It's not a new right. Otherwise, we would have created this new right. When in 2001 it was about to create different categories of rights, and this directive of 2019 didn't create any new category except for the neighboring right for the press organization.
Okay.
Yeah,
so one response. Yeah. And
I think, Tobias, you're absolutely right, is that the 80% of licenses one can cover. Okay, it's what you do with the remaining 20%, and Martin, you came up with some very good solutions there to kind of close the gap. To what extent can government jump in, or where can you kind of shift the nudge incentive on smaller rights holders to come out? Because best efforts here is a very high bar. I mean, short of an absolute obligation, it's about as far as you can go. So does just simply having a statement on your website, if you're a smaller website, that if your rights are on this, get in touch and we'll license, is that best efforts? We'd really welcome clarification for this, and then you can kind of go forwards. And then you have the flip side. Okay, so someone has given you relevant information. We need to have that standardized. We need to have that put in a fingerprint that is a universal fingerprint, so that then you can keep it off. And so these are all of the kind of the steps along the chain that we need more clarification on from the Commission in order to make this workable.
okay, so I think we will now. Okay.
Yeah, possibly yes. As concerns the visual repertoire, if you could also include it, of course, regularly. It has no sense if it's just a platform about completely different things, and there appears maybe one photo or somewhere. I mean, that's clearly, if you have a platform which does not engage into visual arts and photography activities, you don't need to to go there. That's very clear, and I think it's going to be in the practice very clear. When you have so mixed content that comes from any personal, private user, and could contain visual works, it makes sense to have a license, even if it is very little, because you can figure out how much it really is, and that in the end will be a question of how much you pay. I mean, it might be zero, might be very little, but you know you are covered, and you can always discuss with the Visual Arts Collecting Society the subject. It's very good to have collective management. For us, it's clear we have very few players who would license directly, because if we have individual authors, that's somehow not very realistic that they go to platforms and ask for to make a license. So that would be, in our case, more the collecting society, by the exception of picture agencies, of course. There's a special case which we also include. And finally, what I wanted to mention as well, which is very important if you go to collective management, also to cover more of this kind of uses, you need to have this very efficient opt-out at any time, very easy for authors, not because it is used very often. In our experience, it is not, but it gives for the authors who want to keep control over the works the possibility that finally they could intervene and take something down. In reality, it is very seldom happening, because usually they're happy with the situation, and they know that communication takes place over the internet. So it is not a growing or a big thing, but it must be inside all the regulations. No.
Okay, now hold on. So we will try now to see whether there are any questions relating to other sectors. If that's, it may not be, but I think it's right to ask the question. Games industry here, for example.
Hi, I'm a legal advisor for Mediaset Group, which is a member of ACT. So we are talking about, of course, audiovisual sector. And an interesting issue, I think, is how to interpret the term best effort in relation of how fair the remuneration must be in order to get the license. Because as a legal advisor of Mediaset in Italy, we have been showing many video sharing platforms. We started with YouTube in 2009, and we are going on against like Vimeo, Dailymotion, Mega Video. And in court, one of the biggest issue is about how to interpret what is to be a fair remuneration in order to get a license. And what came out is in court, all these video sharing platforms are trying to affirm that it's not the business model of the right holder that has to be affirmed, but the business model that has to be taken in consideration is the one of the video sharing platform, which of course is very different from the one in the sector of the audiovisual sector. So what best effort has to be interpreted as is, I think, a big issue in relation to what kind of business model has to be taken in consideration.
Just want to add something very shortly about extensive collective agreement, because the question has been raised. I don't think that it is feasible in a global world. How could it work? Which entities will collect on behalf of non-members if you give a worldwide or pan-European license? And how do you coordinate, if I may say so, extensive collective licensing agreement and the fact that, according to the CRM directive, Title III, but in the real business also, you have competitors. if you take the label, for instance, they compete. I'm not talking about CMOs, I'm talking about individual management of right. They compete against each other. They will never want that one entity represents their repertoire, because the question is not only about copyright, it's also about the promotion. When you're a label, for instance, when you negotiate with YouTube, you're not just negotiating the fees, you're also negotiating the exposure of your artists. This is as important as the remuneration. So for me, it's for individual management of rights or even collective management of rights, it's very difficult in a global basis to impose extensive collective management of rights.
I'm happy to answer the gentleman's question. You raised a very good point. Whose business model should essentially supersede the others, right? And I've got some views on this, and you never want to be binary on this, but it's one of these ones that simply, if the rights holder asks for too big a fee, then it's not feasible for the platform to license that, particularly if they're dealing with a number of different rights holders there. And so the model falls apart. But there's one important stakeholder that we've neglected in this situation, and it is the creator who is streaming the content on the platform. Their livelihood is at risk if they can't do this. If they can't create engaging content, then no one is going to watch them. And so the, say, 2.5 million European creators that have created a cottage industry off the back of this, their industry will fall away. And also the creativity as well in Europe, the mashup of different cultures and different content to provide something else. So there is, just to kind of point out that there's a third stakeholder in this that we don't see in this room today, and that's one of the things that the Commission also needs to bear in mind when you're implementing this, and I think we touch on in the final session of this talk.
Okay, so I've got one final set of questions here. So it follows up really from Joao's point. Could we conceive the new right as a remuneration right? So is there room for essentially having almost a levy scheme where there's one place in the member state where you go to get your license? And would it be possible to have that scheme in one member state and not in the other member states? And what would be the consequences of that? Okay, so there, again, a set of kind of accelerating questions. So the first one is really the technical question. Is it possible to conceive it as a remuneration right? Joao suggested if you have an opt-out, you might get away with it. Are there any views on that?
I think a simple statutory remuneration right, if it was the intention, this could have been stated clearly in the law.
Of course.
And because otherwise it would be against the principle of the exclusivity of the right. And this legislation has done specifically for the extended collective licensing under Article 12 because of the Soulier-Doc decision, where the court was saying that you cannot have an extended collective licensing where there's no legal basis in the EU law. It created a general legal basis for extended collective licensing for the cases where the individual licensing is erroneous and not manageable and impractical. So this is the basis where you can use the extended collective licensing for the exclusive Article 3 right, which is not a new right. And if it was the intention actually to create a new right subject to remuneration, this should have been done clearly in the law, otherwise it would not meet the three-step test.
So would that mean the German CDU proposal? I don't know whether people are aware of that, but there was a statement, a public statement by the CDU party prior to the European election that filtering could be avoided by having a mechanism of this type. Anybody who thinks that's a viable option?
I think it's against the WIPO treaties. Making available is an exclusive right for both neighboring and authors' rights.
Yeah. Norderman?
Yeah, Jan Norderman, Berlin. I think I have to give you at least that's my opinion, I could give you a typical lawyer answer, it depends. What you can probably not do is introduce an ECL system for entire repertoires of commercially valuable content. For example, for movies, it's probably not feasible to introduce it. That said, maybe for small clips of 2.5 minutes, it would be feasible because it would not be against the 3-step test, because it does not impede the normal exploitation of the work. And I would also not think, I don't know if your comment addressed that the opportunity to do ECL in, according to the new Article 12, would contradict Article 17. Because that may also be, something you have to think about. But in the end, I think both do not exclude each other. So you could use ECL, but only, to certain limits you have. It can probably not substitute collective exclusive licensing where you have exclusive, let's say where you have exclusive exploitation, you cannot supplement that with ECLs.
Briefly.
Yes, just a question back to Joao. What is the difference in your view between a remuneration right with an opt-out and an ECL system with an opt-out? Because in both cases, the exclusive right cannot be exercised because the CMO is under an obligation to license.
Well, it's not a huge practical difference. I was trying to pick on the German proposal and try to see how it worked. Now, of course, the obvious difference in one and the other is the concept of remuneration at stake. So I didn't talk about the fair compensation because it would be a clear exception and limitation. The remuneration right in the jurisprudence of the court or the case law of the court is basically around the concept of equitable remuneration. Now, as was said also here, another possibility is to hook it on the Article 18 concept of fair and appropriate remuneration. But in that case, you could call it a remuneration right, or just you could call it, let's subject it to this principle and get away from the 3-step test issues, and the practical result will be the same. I think that's the main difference.
You had a follow-up? Yeah, okay, yeah. So my last question is, if one member state goes down a route of this kind and another member state goes down the route of sticking with a resistance to enable blanket licensing of this type, would that make constitute a problem for a digital single market, or is it just what we have now? So is it just a levy system? We have a levy system now, and nothing has changed. So then the argument might be, does the directive advance the digital single market, or is it just the same thing as we have now? So I don't think there's a clear answer to that, but I think there is something we can reflect on over lunch. Okay, so I would again invite you to thank the panel. So our break is now